All right, welcome to the inaugural Gregory M. Harvey and Elizabeth M. Wallace Harvey Lecture. My name is Ruth Greenwood. I'm the director of the Election Law Clinic and assistant clinical professor here at the law school. The mission of the clinic is to train the next generation of election lawyers, many of whom are here today, through litigation and advocacy that bring novel academic ideas to the practice of election law. We aim to build power for voters, not politicians, and recognize that the struggle for voting rights is a struggle for racial justice. We are incredibly fortunate to have the brilliant Professor Aziz Huq here with us for the very first Harvey Lecture. I will introduce him in a moment, but I wanted to explain why it is called the Harvey Lecture. Gregory M. Harvey was a graduate of Harvard College in 1959 and Harvard Law School in 1962. Upon graduation, he returned to his native Philadelphia and committed his legal practice to election law and democracy, including endowing this lecture upon his wife's passing. I never met Mr. Harvey, but a couple of things stood out to me from the obituaries that I read. First, there was a quote that said, "He didn't covet the limelight. He was content to labor in the trenches where the less glamorous work was done." And that rings true, I think, to the work of the clinic. We are not huge like, the ACLU. We're a small group, and we find space where students can offer value that is needed and appreciated. We work with community organizers at the local level regularly, and I like to think that Mr. Harvey would approve. One other thing that caught my eye in the obituaries of Mr. Harvey was a quote by a former mayor of Philadelphia, Bill Green, who said of Mr. Harvey, "No recognition, no honor meant more to him than the James Madison Award from the Philadelphia Society of Journalists for his work on the First Amendment. He saw freedom of speech and freedom of the press as the lifeblood of democracy." Emily Mitchell Wallace Harvey was a writer, editor, educator, and scholar. She was a professor of English and served at a variety of institutions over her career, including the University of Pennsylvania, Bryn Mawr, Swarthmore, and finally, she was a research scholar in poetry and visual arts with the Cooper Union in New York. She published dozens of scholarly articles. Both Emily and Gregory, if I may call them that, studied and appreciated language. They believed in the importance of language for freedom of speech and freedom of expression. And so, at a time when freedom of speech and expression and freedom of the press are under attack, it is more important than ever that we gather together across the country in spaces like this to think about, talk about, and debate the democracy that we have and the democracy that we want. And that brings me to Professor Huq. I met Aziz when we both lived in Chicago. I was originally drawn to an accented expat who thought and cared about American constitutional law. Though I would love to equate myself with Professor Huq, I think the similarities end there. Aziz is one of the hardest working and most productive faculty members at the University of Chicago Law School, which is saying something. He's a frequent writer for the New York Times, the Washington Post, Politico, The Atlantic, and other popular publications. He has impeccable credentials. He graduated summa cum laude from the University of North Carolina at Chapel Hill and graduated first in his class from Columbia Law School. He clerked for Judge Robert Sack of the U.S. Court of Appeals for the Second Circuit and then Justice Ruth Bader Ginsburg of the Supreme Court of the United States. He was counsel and then director of the Brennan Center's Liberty and National Security Project, litigating cases in both U.S. Courts of Appeals and the Supreme Court. He then entered academia and is the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago Law School. Though Professor Huq writes about an incredible array of areas on constitutional and comparative constitutional law, his most recent work has focused on democratic backsliding and the regulation of AI, which makes him the ideal speaker for the inaugural lecture. We are so lucky to have him with us today. Here we go.
Thanks so much, Ruth, and thank you so much both to you and to Nick and to Alan and his wife for facilitating the lecture. I understand that in Mr. Harvey's 3 decades plus of work as a lawyer, particularly at Morgan Lewis, he focused on issues of campaign finance, ethics, and the First Amendment. In ways that I think are immensely valuable and worthy of emulation. He was also an important contributor to the public culture, particularly of Philadelphia, where I understand that he was an important patron of the arts. So it's one of his legacies is the installation of Klaus Oldenburg's Kreuzberg sculpture in Philadelphia, along with work by St. Jordaens and Eakins. It's hard to imagine a legacy that a lawyer might leave that is more worthy of emulation, more worthy of admiration if you're a student here today than Mr. Harvey's, where he made contributions not just to the law and the integrity of our democratic system, but also to the public culture of the city that he lived in and apparently loved. So I'm deeply grateful to the Harvey family for endowing the lecture. I hope this is the first of many and increasingly luminous Gregory and Emily Harvey lectures. So what I would like to do in the next 30 or 40 minutes is to offer you something of a diagnosis of where the state of American legality stands. And I want to posit to begin with, or just stipulate to begin with, that there is a close relationship between democracy as a collective political practice and legality. It is hard to imagine how one practices democracy in the absence of a stable set of legal institutions that are operationalized in predictable ways. But at least in the last 2 years, maybe in the last 10 years, there's been what I think is fairly described as a phase shift in the way that law operates in the United States, particularly in and around the federal government. And what I hope to do today is to offer you a way of thinking about that change. To that end, I want to draw upon the ideas of two German thinkers from the beginning of the 20th century, and then elaborate on the diagnoses that those two thinkers offer by way of extrapolating what might be required or what might be entailed by efforts to move ourselves out of the situation that American law is in. The first of the two thinkers that I'm going to draw upon is a German lawyer called Ernst Frankl, who developed a concept that he called the dual state. The second of the two thinkers that I want to draw on is the sociologist Max Weber, who in a book that is now called Economy and Society coined the term patrimonialism, a term that's been used and modified by social scientists, particularly by adding the prefix neo to it. Neopatrimonialism is the key phrase that's used in the social sciences today. And the way that I want to join together Frankl and Weber is by suggesting that one way of understanding the situation of legality in the United States is by seeing it as the output of an application of what Frankl would have called dual state techniques, with the result of, or with the effect of creating a neo-patrimonial state. And having laid out that conceptual framework, I want to offer a few doubts. I want to push on the solidity, the efficacy of the conceptualization. And then I want to suggest something, or sketch at least tentatively, some of the challenges that might emerge in efforts to move us out of a patrimonial state. And on that last point, I'm going to draw in particular on work that I have done with my colleague, Tom Ginsberg, on democratic backsliding. Let me offer two caveats before I turn to Frankl. The first is that I want to be clear that the story that I'm about to tell, the claim I'm about to make, is not totalizing. It is not my claim that the entire federal government or the entire complex of state and federal law in the United States is characterized by what I'm going to call the dual state phenomena or by neopatrimonialism. Rather, the claim is that if there is a significant direction of travel in the nature of legality in the United States, it is explained or glossed well by the use of these two concepts or terms, right? So I think that the way that one would falsify, the way that one would knock down the conceptual framework that I'll try and put on the table is not by showing, oh, look, here's this instance in which legality is still working. It's by showing that the tendency that I'm describing is not fairly capturing what's happening in the United States. So the claim is not one about totalities; it's one about trends or central tendencies. The second thing is I'm going to point to certain examples of neopatrimonialism or the dual state. And in doing so, I want to recognize that I'm going to help myself to the facts of those examples. And we live in a moment in time at which the facts, even facts that are caught on camera, like the killing of Renee Good, are subject to enormous and fraught contestation. It is my view, and I'll develop this a little bit later, that a lot of that contestation are disputes kindled in bad faith, disputes kindled in the absence of any plausible criterion of factual verification being applied in the background. But in order to make the conceptual points that I want to advance today, I think I just have to stipulate to those facts and not address the question of what principle of empirical verification I'm going to be using. So I want to recognize that I'm going to help myself to certain facts in presenting the story that I want to unfold today. Okay, so with those caveats in mind, let me turn to the first of my two helpers, or the two figures who I think are really helpful in thinking through our present moment. So Ernst Frankl was a German socialist. He was a Jewish man, trained as a lawyer in Germany in the 1920s. And in 1933, when the Nazis came to power and German Jews were banned from the bar in large part, Frankl chose to stay. Frankl chose to stay in Germany and continue to practice. There was a caveat in the law that allowed people who had fought in World War I to remain and to continue appearing in the courts even if they were Jewish. And Frankl stayed and practiced as a lawyer, largely representing members of the dissenting church or socialists between 1933 and 1938. He and his wife fled in 1938. When they fled, Frankl had in his briefcase the manuscript of a book that would eventually be called The Dual State, a contribution to the theory of dictatorship. He ended up at the University of Chicago, where he did a degree and completed the writing of this book. The core claim advanced by Frankl in The Dual State is that in his experience in court in the 1930s in Berlin, the state was not characterized by a complete extinguishing of legality. It was characterized by a duality. The state took or had two aspects. On the one hand, much of the familiar and ordinary legal system, which Frankl called the normative state, continued to exist, notwithstanding the brutalities of National Socialist regime as they consolidated their political hegemony. Rather than eliminating entirely the ordinary operation of the ordinary legal system, what Frankl called the normative state, the National Socialist regime put in place a second parallel zone, which Frankl called the prerogative state, in which it was possible to exercise, and I quote, unlimited arbitrariness and violence unchecked by any legal guarantees. So alongside the normative state was a prerogative state where the ordinary law that bound state officials in particular simply did not apply. On Frankl's account, the distinctive quality of the dual state, which was the system as a whole, was the fact that officials had a power to switch individuals from the normative state into the prerogative state. People or cases could be jerked out of a domain in which the ordinary rules of law applied into a domain in which there were no limits to what the state could demand or what the state could do. Here's a simple example that comes from Frankel's own litigation experience. And I picked the example, there are more vivid and violent examples that involve the transfer of people eventually into the concentration camp system. But I think it's useful to have an example that's actually quite ordinary to show how this works. So in 1936, in July, Frankel was representing a group of employees of a union. And the union had been taken over by the National Socialist Party. It had been Nazified. And as a consequence of its Nazification, Frankel's clients had lost their pension entitlements. So Frankel goes to court, makes the argument that the change in the character of the union did not eliminate its obligation to pay pension entitlements. And the judge finds on behalf of his clients, and the judge orders that the union pay his clients their pension fees. There's no appeal, and Frankel goes home thinking that he's won the case. A week later, his clients call him and say, well, we haven't received any money. And Frankel goes back to the court and tries to work out what happened. And what he learns was that after the judgment, a member of the Gestapo who had been in the courtroom at the time had later telephoned the judge and told the judge, no, whatever it was that you were going to order, tell the union not to deposit the money into the bank account of Frankel's clients, but to deposit into our bank account, the state's bank accounts. So in this very ordinary case, the state, in the form of this agent, comes in after the after the law had been applied by a court and simply switches off that law. So the suggestion that I want to advance is that the second Trump administration has found ways to use what Frankel, I think, would have characterized as dual state techniques in a way that does not have any obvious parallel in American history. And I want to suggest that there are two different ways in which we see something like a dual state playing out today. And I'm going to call these, just as a way of sort of fixing them in your mind, the kill switch and turning kindness into a knife. Now, what do I mean by those two phrases? First, the kill switch is a way to negate the force of an otherwise applicable law, either by invoking a legally endogenous, something that's within the law, authority, in a way that is simply factually unmoored, or by the brute act of simply ignoring a law or a court order that otherwise would apply. The kill switch works differently across different areas of the law. In immigration, in environmental law, in consumer protection law, and most recently in international law, we see various iterations of it at work. But let me give you a couple of examples. I think that the most obvious and the most powerful example is the case of Kilmar Abrego Garcia. Abrego Garcia, as many of you will know, was arrested and deported to El Salvador and became a symbol of lawlessness when, notwithstanding the existence of legal orders requiring that the administration facilitate his return, he remained in El Salvador in detention under conditions that are, to put it mildly, harsh for several weeks. The Abrego Garcia case is, I think, probably the most high-profile instance in which the administration simply ignored a legal order, but it's hardly the only one. Moreover, there are several species of instances in which policies or actions by the administration have proceeded in ways that show a facial disregard for otherwise applicable law. A couple of examples of these, again, I think which are all quite well known. The arrest of students at universities like Columbia and Harvard on the basis of political speech that is protected by the First Amendment, the promulgation of executive orders targeting law firms based upon their prior representation of the president's political foes, and most recently, the targeting of the technology firm Anthropic on the basis of a statutory authority that simply does not exist. The kill switch took its perhaps most vivid form in the report, the newspaper reports that a senior Justice Department official, a man called Emile Bove, was instructing lawyers and agents of the government in colorful language to simply disobey court orders and not to tell the court that what they were doing. There is a second major movement to the emerging dual state. This one arises when the government defies laws that regulate its awesome fiscal powers. And it uses those fiscal powers in ways that are illegal to extract intolerable and unlawful concessions on the part of private or state actors. The federal government in the United States is in practice coordinated. It operates through cooperation as much as it does through coercion. It cooperates with state governments in programs like Medicaid and Medicare. It cooperates with private actors in the provision of social services. It cooperates with universities such as Harvard or the University of Chicago in the creation of the public good that is the social and the natural sciences. It works, in other words, through what the sociologist Michael Mann calls infrastructural power, as opposed to merely despotic power. But because this cooperative form of government means that state and private entities, such as Harvard, such as the University of Chicago, come to depend upon federal government, federal monies, the ability to preemptorily deny those federal monies becomes a powerful lever to be used against those entities. So I don't need to tell you how that has played out at Harvard, but let me give you a different illustration. Early in 2025, the administration took the view that a Maine law, the state of Maine, a Maine law that permitted trans girls to compete on sports teams was inconsistent with its view of civil rights law. Maine's governor, Janet Mills, took a different position and took the view that the Maine law was not preempted by federal law. At the time, there were 2 children participating on girls' teams as trans girls. The Department of Agriculture informed Governor Mills that unless Maine removed those 2 girls from the relevant sports teams, it would cut off all of the funds the federal government was supplying for hot school meals for impoverished children in the state of Maine. That is, the federal government presented the state of Maine with a choice. Either comply with our understanding of who counts as a girl and who counts as a boy, or let your children starve. This is an instance of a cooperative relation that is being flipped around and turned into a weapon. And that's why I use the phrase kindness turned into a knife. Are there reasons for being skeptical that this modality is something new, or doubting that Frankel's dual state framework fits our current moment? Here are 2 ways I can think of pushing back on the application of Frankel's ideas to the present moment. The first is that Frankel's dual state model, this idea that the state can switch off the law, assumes, or it helps itself to the assumption that there is a clear distinction between what is lawful and what is unlawful. And in that sense, it ignores the phenomena of what H.L.A. Hart called hard cases. It ignores the fact that there's a large domain of potential disputes in which the force of legality is itself unsettled. Further, the dual state framework helps itself to the assumption that if there is a law that forbids or permits a certain action, there is necessarily a remedy for a violation of that law. But at least in American constitutional law, it has long been recognized that there is a large gap between the law as it exists on the books and the remedies that are available, particularly to private parties. In both of these ways, it might be that the clear distinction between lawful and unlawful acts, the idea that you could have the law apply and have it be switched off, which I think is central to Frankl's model, may be more fragile than Frankl's original work allows for. It may be that what we would characterize as the rule of law is actually much more contingent upon social facts, conventions, and unstable remedial equilibria than he would recognize. The second objection that one might make to the application of the dual state theory today is that it doesn't capture an important possibility. Frankl, like most other theorists who model or think about the rule of law, assumes, again, helps himself to the assumption that judges act as fair-minded arbiters of the law. That is, when the law is violated, the judge says the law is violated, X follows or Y follows. And neither Frankl nor rule of law theorists more generally account for the possibility of a system in which judges act as regime-aligned actors, rubber stamping most or all of what a lawless ruler does. The possibility that judges might act not as arbiters of what is or is not lawful, but might act as facilitators of a regime is illustrated, I think, by the career trajectory of somebody I've already mentioned. The lawyer who advised officials from the Justice Department and the Department of Homeland Security to ignore court orders was a man called Emile Bove. Emile Bove is now a judge on the Third Circuit Court of Appeals. It's not clear to me how the dual state model accounts for a world in which the judges are captured by the regime that wishes to negate the force of law. Okay, so let me bracket those concerns, those worries about the model, and let me turn to where the dual state dynamic leads us. And to think about that, I find it useful to draw upon the work of, he's a little earlier than Frankl. Max Weber, a founder of sociology, is writing at the end of the 1800s, the beginning of the 1900s. Many of you will have encountered his very famous lectures, Politics as a Vocation and Scholarship as a Vocation, which were written in 1919. Weber dies a couple of years after that in the Great Flu epidemic. One of the features of Weber's work is an effort to taxonomize, to think through the different categories of legitimate rule. And it is in that element of his work that Weber draws a distinction between two ways, or a number of different ways, in which legitimacy, that is, the belief that a particular government or ruler has rightful authority to issue commands, how legitimacy is produced. And to that end, Weber distinguishes between legitimacy that is generated through rational and legalistic bureaucratic action on the one hand, and a patrimonial model of legitimate government on the other hand. I want to draw upon the second idea, and let me tell you what Weber meant by it and then how it has been elaborated after his time. So on Weber's account, a patrimonial system of government is not one that is channeled through, not one that acts through laws or predictable bureaucratic systems. It is a form of legitimate domination in which the ruler and his staff fuse administration, the work of the state, with their personal authority, yielding, and this is Weber's phrase, a state that operates like a family business. Weber's concept of patrimonialism has been taken up particularly by social scientists and political scientists who study the African state. It's a controversial term, or it's a controversial term, and many have disputed the extent to which the African states generally, to the extent that one can generalize across a vast and diverse continent, warrant the phrase patrimonial. But it's a discourse that has stuck and has developed refined definitions of what Weber called patrimonialism. Probably the best of those, the one that I think is the most helpful, is from a 1985 paper by Christopher Clapham, who argues or who offers a definition of neopatrimonialism as a political and administrative system which is formally constructed on rational legal lines, but where officials exercise their powers, and I quote, as a form of private property, right? So you have a rational bureaucratic shell, but you have officials moving through and acting through that shell in ways that are not well explained by law, but well explained by their own personal, parochial, familial, clannish interests. I think that neopatrimonialism, as understood in this theoretical tradition, offers a useful lens for thinking about where the American dual state leads us, which is the pervasive deployment of public power, either for the entrenchment of a political faction in office beyond any plausible shift in electoral sentiment, coupled to the systematic use of government powers, particularly of regulation, in order to extract and concentrate wealth, either within the ruler's own clique or allies to that clique. I could offer a really long list of American neopatrimonialism today. But let me offer, rather than giving you the big long list, just a couple of examples, but examples that tie that idea back to my two modalities of the dual state. So let's think about, or let me provoke you to think about how the kill switch and turning kindness into a knife can be employed in ways that have neopatrimonial effects. So here's the first example. So in January of 2025, so immediately after the inauguration, the White House announced that it was suspending the application of a federal statute called PAPAPSA, excuse me, it's a hard one to pronounce, that required it to prohibit the social media app TikTok. That statute had recently been upheld by the US Supreme Court and seemed to brook no exception to the requirement that TikTok not be made available in the United States. Nonetheless, the Justice Department said that it was not going to enforce that law, and a series of negotiations unfolded in which the end result, announced in January of this year, was that TikTok was being acquired by a coalition of investors led by close allies of the president, including Larry Ellison and the president's son-in-law, Jared Kushner. That's an example of the law being switched off, the kill switch, generating an outcome that benefits the immediate circle around the president. 6 months later, here's a different example of the kill switch. 6 months later, the White House announced a deal with the chip maker NVIDIA. NVIDIA had been subject to an export ban concerning certain, or that applied to certain advanced chips used in AI applications when those chips were being sent to China. The announcement said that there was going to be a suspension of that export ban on condition that NVIDIA gave a tranche of the profits from those sales to the federal government. That fee is flatly unlawful. The export control statute upon which the president relied for his authority to prohibit the export of NVIDIA chips contains a provision that explicitly prohibits licensing fees. It follows from that that there is no provision in federal law that regulates how the money from this unlawful licensing fee is to be allocated. And a net effect of this is that the president, through this NVIDIA deal, and I could have made the same point with trade deals that had been struck with Japan and South Korea, both of which involve large transfers to the United States outside the scope of any kind of statutory framework, creates a slush fund that can be used by the White House for whatever purposes it wants. What about the idea of turning kindness into a knife? Well, I think that the most powerful example here is the way in which the Federal Communications Commission, led by Brendan Carr, has exercised its authority with respect to mergers, particularly in the media sector, in order to demand compliance with the ideological line set by the White House. The more recent example of this was the threat, again made by Carr, against media companies that they would face regulatory scrutiny if they did not provide a sufficiently rosy view of America's present military adventure in Iran. Here's a final example of turning kindness into a knife. Well, it might be an example of the kill switch either. There was a recent report that a personal friend of the president, a man called Paolo Zampoli, he was the person who introduced the president to his spouse, had successfully called the White House asking for the immigration services to deport his ex-girlfriend so that he could obtain custody over their child. She was deported. Is there reasons for skepticism of thinking about, or for using neopatrimonialism as a model to understand the current state of the government, or the current tendency or trend of the government? I think there is, and I think that the reason for skepticism of the model would run, or one reason, you can tell me others, one reason might unfold along the following lines. Isn't the existence of interest groups or individuals who are proximate to officials in apex positions of government, like the president, isn't the existence of those interest groups or individuals and the power exercised by those individuals endemic? Isn't that just what, in the pluralist tradition of political science, we would call the play of faction, or something of the kind? And hasn't this kind of influence been persistent, endemic even, through the democratic tradition? So if you go back to the very, very first description of a democracy, which you find in Herodotus's history, Herodotus describes the first democracy that's established in Greece by Cleisthenes at the beginning of the classical period. And Herodotus goes out of his way to say, well, the way that Cleisthenes exercises his power is through something called a hetereia, which is faction. So right at the beginning of democracy, you have something that looks an awful lot like patrimonialism at work, rather than some sort of Habermasian ideal kind exercise of public reason. Okay, so to recap, what I've tried to offer you in brief form is a mechanism and an endpoint. The mechanism is the dual state, the ability to switch off the law with respect to cases or persons who are disfavored. And the end state is the Weberian neo-patrimonial state. I want to finish off by asking, or by putting on the table, a question, which is, what are the problems that arise when a neo-patrimonial state of the kind that I've described, built through dual state tools, has been constructed? what are the problems that arise in trying to unravel that and return us to something more familiar, or more appropriately called the rule of law? One way of thinking about that question is by noticing what gets lost and what gets gained in the context of the trajectory that I have described. So think first about what gets destroyed or degraded by this process. Well, the dual state, the existence of the dual state, is inconsistent, is incompatible with the relations of mutual trust and interdependence that exist or ought to exist between a democratic government and the citizens and the entities that it regulates. Right? The very fact that the government can turn off the law, as it has tried to do with Harvard, is inconsistent with Harvard in the future being able to trust this or any other federal government. Once you have had the knife put to your throat, you always know that the knife could be placed back there. That knowledge is inconsistent with the relationship of mutual trust. Another thing that we have lost, and that we have lost as a consequence of the naked instrumentalization of legal tools, is a capacity to believe that we have a culture of rational legality in which exercises of coercive power are presumptively justified. It is impossible to know, and it is impossible in the future to be certain, whether any given exercise of coercive power is indeed justified by law, or whether it is an example of the dual state at work. Every instance of coercive power, that is now, raises, in a way that I think is new and distinctive, the question of whether it has been done in good or in bad faith. And at minimum, that means that there is a persistent and new cost of figuring out, in any given instance, whether a prosecution, whether an act of violence, like the killing of Renee Good, whether a particular act of regulation of the kind that Anthropic is facing, is an instance of the law being applied, or an instance of raw political expediency. But how does that determination get made? Well, that leads to, or points toward a further deficit. Once upon a time, the reputational standing of agencies and entities within the government, such as the Justice Department, or the National Security Council, or the FCC, was such that they warranted a presumption of trustworthiness, a presumption of regularity, as we lawyers like to say. But given the corrosive, or the corrosion of that norm of legality within government, the ordinary actors that we would look to determine whether a specific action was lawful or not are no longer available. We cannot rely upon a presumption of regularity. We cannot assume, because the Justice Department has said there is sufficient evidence to bring an indictment against this person, that there is indeed such evidence. The goalposts, the referees, have been degraded, if not destroyed. And then think about, on the other side, not just about what we've lost, but what is new. One of the things that the dual state leading into a world of neopatrimonialism generates is new constellations of both public and private power that will outlast the administration, the particular regime that has produced them. The new owners of TikTok, of CBS, of Face the Nation, of CNN are not likely to blithely accept a change in the political climate, nor will the officials, including the judges, who are appointed by and who have demonstrated a remarkable loyalty to this particular regime. These holdovers, these concentrations of power that are created by the dual state and neopatrimonial processes that I've described are going to fight tooth and nail to prevent a return to liberal legality. And they will have no hesitation in using the rhetorical tools of liberal legalism to achieve that end. This is not just speculation. This has been the experience in Poland. Poland had a backsliding government, the Law and Justice Party, led by the Kaczynski brothers, that in 2024 lost a parliamentary election to the centrist politician Donald Tusk. Tusk and his allies since then, however, have found it immensely difficult to return Poland to a position of stable legalism because of the resistance of members of or allies of the Law and Justice Party who are entrenched in the judiciary, in the bureaucracy, and in the media world. And one of the most paradoxical elements of that resistance is the successful deployment of the rhetoric of legal liberalism against the project that Tusk has advanced. I think that paints a relatively bleak picture, but I don't want to end on a pessimistic note. So as Nick and Ruth know, you do know, right, where this is? Actually, do you? Can I do Socratic quickly?
Well, of course I recognize the city.
Yeah, but do you know where in the city it is?
A view of the Acropolis.
It is a view. So this is. I was recently in Greece, and this is a photo I took in Greece. But it's a particular place. This is a place called the Pnyx. The Pnyx is the hill where Cleisthenes first called into being the first public assembly that is the kernel of Athenian democracy. I did look this up, and according to Paul Cartledge, who's the leading historian, you can't call it a democracy at that point. At best, it's a proto-democracy. But this is the place where at least the Western tradition of democracy began. And if you go there today, it's a hill, and it's an empty hill. There's nothing there. It's the middle of a park. But you have this wonderful view of the Parthenon. Of course, after Cleisthenes founded that popular assembly, the Parthenon was burnt to the ground by Persian invaders in 480 BC. 80 years after that, Athenian democracy was completely abrogated by the 30 tyrants between 403 and 404 BC. Even within the span of Athenian democracy, classical Athenian democracy, the institutional forms that enable democratic rule evolved and changed and adapted in the face of seemingly overwhelming threats. The lesson that I would take from my visit to the Pnyx, which is the name of this hill, is that democracy moves on. It adapts. It changes. So maybe the original space where democracy was founded today is an empty hill, but that doesn't mean that democracy's opportunities have been exhausted. The virtue of democracy, in other words, is its capacity for endless reinvention. Its possibility of being swept away, as it was even in Athenian times, but then being rebuilt, reimagined, and built better against the relentless tide of events and countervailing forces. Thanks.
Thank you very much, Aziz. That was a powerful and troubling framework that I think does capture some important aspects of our current political and legal moment. Let me ask you a couple questions and then see if folks here have additional comments or questions for you. So one question about the dual state model. It seems to assume a competent, efficient regime that is capable of deliberately switching law on and off. And so I wonder how you pair the model of the dual state with some of the incompetent, chaotic, inefficient aspects of our current administration. Can you have a real dual state when both sides, both the normative state and the prerogative state, are run with a large dose of chaos and confusion. That's one question. The second deeper question, I guess, goes to both of these concepts. Frankel's book referred to dictatorship and characterized the dual state as a sign or a symptom, maybe a characteristic indicator of dictatorship. And that seems too strong of a claim. It seems very clear that both neopatrimonialism and the dual state are inconsistent with the rule of law, inconsistent with standard liberal legality. But I think there are plenty of governments around the world that I wouldn't characterize as dictatorships that have dual states and neopatrimonialism. Think of Mayor Daley's Chicago, think of Greece under Papandreou, think of Italy under Berlusconi. I don't think these are dictatorships, but they do have dual states for friends as opposed to enemies of the regime, and they also have plenty of enrichment, aggrandizement by the regime. So I think they have, the patrimonialism aspect as well without dictatorship. I'll stop there.
Yeah, no, I think that's great. So let me do the second first and then go back to the first. Frankel was trying to explain the fact that German democracy collapsed under circumstances in which the overwhelming majority of non-Jewish Germans maintained a relatively high level of support for the regime. And the dual state theory was an effort to explain how the German National Socialist government delivered the public good of legality to the overwhelming majority of Germans at the same time that it could instrumentalize the available resources of the legal system and the coercive state against its enemies. So it was a way of explaining the collapse of democracy in 1930s Germany under conditions in which the regime collapsing democracy actually in this peculiar way had a democratic claim to credibility, which is that they maintained the support of a large proportion of let me be very clear, the non-Jewish, non-socialist portion of the population. There's no reason to think, consistent with what you say, Nick, that the employment of the instrument, the tools that Frankel identifies, and in particular this idea of a switch and this idea of two distinct domains of the law, necessarily needs to lead you all the way to the outright collapse of democracy. And indeed, one of the important, I think one way of taking your question and using it productively or expanding on it productively is by noticing that since Frankel wrote, political scientists, particularly your political science colleague, Steve Levitsky, have identified this large category of what he calls competitive authoritarian regimes, which are intermediate between democracy and dictatorship. And one way of thinking about the dual state techniques is that this is one of the instruments that can be employed to move us in varying ways or to varying extents along a kind of linear scale from democracy to competitive authoritarianism through dictatorship. So I think about how that, I don't know enough about Greece under Papandreou to be able to speak to that, but think about how that might be applied in the United States. It might be the case, right, depending upon what happens in November, and you guys in the clinic are clearly going to be thinking about this a great deal, that, depending upon, how many ballot boxes are seized in how many states, and how many ICE agents are outside how many polling stations in how many states, that the dual state moves us actually a pretty far ways, even in the next 12 months, toward at least into the zone of competitive authoritarianism, right? And my own view is it's very hard to know how far along that road we're about to travel, right? I think it depends on many contingencies. But I certainly don't think that you need to say we're going to move all the way to dictatorship to think that it's useful to use this frame of the dual state. And I want to completely embrace the other thing that's implicit there, which is that Neopatrimonialism, the sense of a clique or a clan or a family or a cluster of individuals who are treating the state as, in effect, the source of revenue that they can extract for their own personal benefit, I don't think that that is distinctively attached to the dual state. I think that is something you see in many, many places in many, many different ways. And indeed, so I'm in the midst of writing a book on the dual state and thinking about it in different contexts. The other leading context where you see a dual state today, I think, is China, which does have a kind of parallel, there's a formal legal system, and then there is a parallel system of extra-legal detention and coercion that is operated by the Communist Party. Right? Actually, the Chinese system has all the characteristics of a dual state, but it's not a neo-patrimonial state in the same way. I mean, there is some corruption around Xi and enrichment of these sort of the neo-princelings, but by no stretch of the imagination is it a state that is corrupt in the way that I think that you could plausibly describe our present administration in the United States as corrupt, right? So there's an example of the dual state and neo-patrimonialism actually coming completely apart. I think that on the first question, one of the characteristics of the present administration, because I think your claim is about the present administration. One of the things about the present administration that makes it so hard to grasp and conceptualize is its addiction to spectacle. And spectacle, in this moment, means doing as many things as you can, as quickly as you can. So we haven't finished whatever it is that you thought we were doing in Iran, and we're going to do Cuba too, right? That's an example of spectacle, right? Even as, Tehran is being bombed, the White House is telling the Justice Department that how dare you abandon these lawsuits against the law firms. You have to appeal them even if there is no legal basis to appeal them. Oh, and by the way, we're using Anthropic's Claude model to target in Iran, but we're also going to designate Anthropic as a supply chain risk, for which there is no statutory basis, right? It's another unlawful action. It's not even a plurality of actions, it's this density of spectacular, newsworthy actions, which I think evinces or sort of suggests a kind of addiction to spectacle, is one that lends itself to multiple explanatory frameworks at once. And so I think it is perfectly coherent to say that there is this strand, and I think it's a really important and durable strand of what the government is doing now, what the administration is doing now, that can be characterized in dual state terms. But there's also all of this other stuff that is just, in your polite phrase, chaos, right? And I think those two things can coexist because you have a government that is addicted to spectacle.
Yeah, why don't we take one question from somebody here, if anybody has a point. I have many more, but I can share those with Aziz later.
Yeah, Jack? So the dual state, right, conceives of two fully separate states that are kind of segmented from each other. What does this framework gain from viewing the dual state that way, rather than something like protection of the laws is just conditionally granted? You're always within a state, and maybe there's actually no difference to what I'm saying, where the government is just offering you a condition that they can revoke at any moment, rather than two separate things.
Yeah, I think that the way that, I think that you're picking up on a confusion in the way that Frankl uses the word state. And I have to confess that I have read the book in English because I did German for 2 years, 13 and 14. It turns out 14-year-olds, nothing sticks. So I could try and read it in German, but it would be a catastrophe. I think that there are two meanings of the word state in English that are easy to confuse. The first is there is the state as the formation through which public power is exercised in reasonably stable institutionalized forms. And then the second is the states in the sense that we would use that word in the phrase states of matter or states of being. And I think that Frankl is talking about states in the second sense as opposed to the first sense. In the sense that there is one sphere of action in which what the state does is predicated upon law, right? It satisfies the condition of the genealogical condition of being able to trace back some given state action to some, usually written, but in the Anglo-American tradition, which doesn't exist in Germany, right, that you can also have a common law authority, right, but you have some basis in legal authority for what the state does, right? That's one state where everything that the state does, there's a legal story, a legal genealogy to be told. And there's this other state where it simply doesn't matter whether there is either a legal genealogy, where the state can say, we have this power because there is this ex ante authorization in the form of statute, in the form of the constitution, in the form of the common law, or even if there is a clear prohibition. So think about my example of the NVIDIA chips, right, which I think is a really, or you could do this with Anthropic, right, where it's very, very clear if you look at the statutes that what is being done is just flatly unlawful, right? And I think that's it's almost like a different state of matter or a different state of mind, not a different state in the sense of the federal state versus the state of Massachusetts, the Commonwealth of Massachusetts, or what have you. Does that help? But you know what it prompts me to think is that I should go back and look at, or I should ask a German LLM to go and look at the book and tell me what the book says in German, not English.
Thank you. That is all we have time for, folks. Thank you so much to Professor Huq for coming here today, and thank you all for being here.
No.